when we spoke of the clauses 20, the clauses dealing with cyberbullying and harassment, you know, sir, there's language that talks about disseminating information without regard to whether it is true. And I feel like that is not just admirable or appropriate language in the legislation. I feel it is an appropriate lesson for all of us. Because we receive something on a phone, we hear somebody whisper something, and we believe that we can just continue to replicate information that we do not know to be true. We have not checked. It is not in evidence that we can be objectively verified. Someone has said it, and we choose to share it. You see on your WhatsApp forwarded many times. A person decides, without regard to how it will affect the member for St. Thomas, the member for St. Michael West, they do not care. As far as they're concerned, I got it on my phone. And you will hear that often in the hallways. You heard about so-and-so, I got it on my phone. I can send you. Without, what's the language? Without regard for whether it is true. And it is time that people are accountable for their role in originating that information without evidence and then disseminating that information. You know, it is no laughing matter. People have their professional lives. People have their families. People have to walk the streets of this country with their heads held high in cases where they have done nothing. And it is no small thing. You cannot just start rumors, perpetuate rumors with malicious intent and not be accountable. And so, the mutual assistance component of this means that where people do this, generate information that they have not checked, that in many cases they know to either be false or unverified. They sit in an apartment in New York City or in Brooklyn, in Jamaica, in London, in Manchester, and believe that because the Barbados Police Service has no jurisdiction there, that they can get away with it. Well, no longer under this legislation. Sir, we similarly received some feedback on the question of illegal devices, and it was suggested that where Clause 9 makes reference to a person who intentionally or recklessly and without authority produces, sells, procures devices for the purpose, primarily designed for the purpose of committing an offense. This commentator suggests that there are a number of dual-use programs and applications which can be used for legitimate testing and similarly for hacking that would cause harm. And we make clear that the devices covered under Section 9 are devices that are primarily designed or adapted for the purpose of committing an offense. So it necessarily excludes devices that have a legitimate primary purpose, such as the dual-use devices that are mentioned by this individual. So any activity such as ethical hacking, which is conducted with authority, would not be covered as unlawful or what would not be considered an offense under Section 9. Similarly, disclosure of access codes that is referenced at Clause 11. This commentator considers that there are several legitimate reasons for sharing access codes. Again, it is difficult for us to consider a circumstance in which you would permit the disclosure of access codes without authority. In every case, authority is the determining factor here. And so yes, if I share my password with a member for Christchurch East Central, and he gains access to my device, then he has authority. And the matter would not be considered unlawful under the Act. Clause 12, that relates to critical information infrastructure systems. And it defines a computer system, or defines this as a computer system or a part of a computer system, whether physical or virtual, a program or data containing information that is vital to the security, defense, and international relations of Barbados, the provisions of service directly related to communications, banking, and finance, the protection of public health and safety. So those are all categorized as critical information infrastructure systems. A person who, without authority, gains access to those systems is liable on conviction or indictment to a fine of $100,000 or to a term of confinement, etc. Again, the commentator considers that the list of critical information infrastructure is too limited in scope and a broader list should be published. However, our response to that would be that it is not advisable to require the establishment of an exhaustive and complete list that is designated as critical infrastructure, because the things that are considered critical may change from time to time. So it would make it impractical for us to identify all and itemize all of the things, the various devices, the locations, the systems that would comprise critical infrastructure. It is not a viable suggestion. And it is our consideration that the definitions that are established herein mean that whenever there are changes in what is designated critical infrastructure, that we can respond. There have been, and I should say that these comments are originated from one individual, so I don't want to give the impression that these are multiple concerns. There have been concerns about the notion that the cyber terrorism definition is too limited in scope, but the terrorism is already defined under Section 22 of the Anti-Terrorism Act. And so the cybercrime bill draws on the definitions of terrorism as outlined there. With respect to search and seizure, Clause 23 makes provision that where a magistrate is satisfied on information on oath given by a police officer that there are reasonable grounds for suspecting that an offense has been, is being, or is about to be committed, the magistrate may issue a warrant authorizing any police officer to enter and search that place, including any computer system, using such reasonable force as is necessary. The commenter feels that this gives law enforcement excessively broad powers when it comes to confiscation and access to computer systems. However, this legislation, like all other legislation, provides independent oversight as it requires the police to obtain a warrant from a magistrate based on specified grounds. So the same way that you would need to obtain a warrant to gain access to a physical place, you similarly must obtain a warrant from a magistrate based on specified grounds, and the magistrate has discretion in terms of which specific powers will be granted to search a place. It does not mean that the police authority does not have to act in a correct manner to gain access to a person's property. It does not remove that requirement. But it is not new or different to the extent that it makes use of the standing system and the requirement to obtain a warrant as it would in any other criminal matter. And finally, the question of production of data for criminal proceedings. Again, the complaint is the same, that it gives, Clause 26 gives law enforcement excessively broad power and intrusive surveillance powers when it comes to intercepting internet communications. I want to make clear that this power is limited in the legislation to seeking production of specified computer data. That is how it is framed and exists under the Budapest Convention that most other countries follow. This provision does not enable surveillance or interception of communications. It is limited to stored computer data and to subscriber information. So I think perhaps the commenter misunderstands the provisions because it does not enable surveillance and interception of communication. It in fact enables only specified computer data that is stored in cases where a judge or a magistrate is satisfied that based on the application of by a police officer, that data is required for the purpose of a criminal proceeding or a criminal investigation. Sir, I turn now to my final area of conversation or explanation. I consider that there will be future occasions to go more in depth into the cybersecurity strategy. This cybercrime legislation does not and cannot cover all areas of cybersecurity strategy. There are resources that have to be brought to bear that, for example, will allow for certain forensic tools to be used, that would allow for certain cybersecurity-related hygiene that has to be carried out, that would allow for response teams, that would make provision for reporting of cybersecurity incidents and make those mandatory within certain government frameworks. There are options, sir, that we continue to explore as part of the cybersecurity strategy to also give citizens the wherewithal to see who has accessed their data and for what purpose. There are countries, I believe Estonia is one, where citizens are able to, or perhaps not Estonia, but where citizens are able to see where some of their information as stored by government has been accessed and for what purpose. I say these things to say, sir, and of course we have to invest in having cybersecurity resources, professionals, people who are engaged to make sure that each area of information where it exists, to make sure our data centers are secure. These are all parts of the strategy. In no wise am I suggesting that a cybercrime bill ticks all the boxes, and it is only one part of what our efforts will need to be, along with education of the public, because there are some things that we all do that we should not be doing if we are serious about securing ourselves in an online environment. And we will, in coming weeks and months, engage the public fully on some of those other cybersecurity efforts. But I want to come finally, sir, to the last set of concerns that have been circulating, and I thank the individuals who met last Friday, who earnestly and in good faith discussed their concerns. And I just want to briefly respond to some of them. Some of the concerns that were communicated by citizens of Barbados, the document frames the group as citizens of Barbados asking government pertinent questions about the Trident ID and Barbados Identity Management Bill. The document was drafted on the 26th of January this year. So I consider that some of the concerns that have to do with rights and access to goods and services are addressed by the information that I shared earlier in my ministerial statement, which removed the deadline, and in so doing, removed any requirement to have the digital ID in order to access those goods and services. So I think that much of what has been outlined as a concern, that provision removes that, and I reiterate that the BIM Act, Barbados Identity Management Act, will need to be amended, but we will be careful and intentional with those amendments to give effect to the intent, but that administratively, in terms of policy and practice, that is how we go forward from here. But I wanted to come to a concern of the group that has to do with the information that is collected by the Electoral and Boundaries Commission and the extent to which it is vulnerable, or it might be vulnerable, to be disseminated in ways that are not authorized. First, let me clarify the information that is associated with the card. There is a set of information that is available visually on the face of the card. Your national ID number is available visually on the face of the card, document number, your names, given names and surname, the date of expiry of the card, sex, a standard 2D photo, your nationality, date of birth, whether you are a senior, whether you are a person with a disability. There's a QR code that when it's scanned shows your driver's license information. It shows the driver's license information that is available on the face of your driver's license. And there's a QR code that on a minor's card, when it is scanned, it shows the minor's guardians, primary and secondary. So that's available on the face of the card. And that is very much in keeping with what has always been available on the face of the card. The only new information collected in this registration has been disability category once volunteered. It is voluntary to submit that information. A secondary guardian before minor cards, for minor cards, the only information that was collected was a primary guardian, but from a position of protection of children, it is important to be able to have access to who might be a secondary guardian in cases where this information needs to be made known. And then the permission to place the word disability on the card. That is the only other thing that is new. Secondary guardian for minors, the category of disability when people opt to give it, and then the permission to place the word disability on the card when people opt to have that on their card. There are many Barbadians living with disabilities who want people to have that information up front because it relieves them of certain conversations and justifications that are very uncomfortable and difficult and quite frankly unnecessary. So that is the only new information collected as part of this new registration process. Everything else available visually on the face of the card was always available visually except for what are called MRZ lines, so that set of code that you see at the bottom. the information that is protected by your PIN. Now, the question was asked by the group, is pinning of the card mandatory? I think I have satisfied most Barbadians that nothing from here is considered mandatory. But the PIN and the chip technology is what makes the card digital. If you don't have the capacity to have information that is securely stored and made available to certain institutions with your authorization, that is your PIN. And the cybercrime bill, once passed, will now make it an offense for people to illegally access your PIN. So unless you give your PIN to someone, a person cannot legally access any information that is what we call behind the PIN. Because it is your PIN. It is like having a credit card, an ATM card. You use it yourself. So, and you have to choose to go in and choose a PIN and PIN the card. So it is not mandatory, but if you want to transition the card from just, again, being a prettier version of the plastic ID card, if you want to transition the card in terms of functionality from there to being able to be used in different environments, and I'll revisit in a second what those are, then you may choose to PIN the card. The technology that the EBC is now working on, in the case of seniors and being able to ride free of charge on the transport board buses, requires, unless it will be a contactless technology, it requires the PIN to be used. I say requires because this is a benefit. To be able to securely, let me put it another way, to verify that it is you riding free of cost. Only one person presents with that set of attributes associated with that PIN. And so it is a way for you to have comfort. You know, we have all kinds of cases. Less so, obviously, in the case of transportation. More so in the case of pension checks. Getting access to people's pension. It is in the interest of an individual to be able to prove that it is you or that you are unequivocally authorizing a third party to carry out a transaction on your behalf. It is in the interest of the user. That security protects the consumer. And so the information that is PIN protected, place of birth, as in country, that is what we call behind the PIN. So you enter the PIN, you see that information, or the person that you were giving the card to and entering the PIN in front of sees that information. Date of issue of card credential, marital status, height, address, parish. You have the option, sir, to share your home phone number, your mobile number, your email address. You have the option. And disability category. So, sir, you will hear from that explanation. And then, of course, there's the information on the driver's license, which is shown when the QR code is scanned, which is, if you look at your driver's license, which is also on the driver's license. I say that to emphasize, sir, that the information fields that I've just outlined can hardly be considered sensitive information to the extent that they're either already on the face of your ID card, to the extent that they are, in the second case, behind your PIN, so they're accessible when the PIN is entered. And sir, I am not at all trying to be facetious. I take these comments in good faith, but your name and address and phone number are in the phone book. They're in the directory. And so I think part of the conversation that we want to have is what is the information that we are comfortable sharing? Because I want us to understand that, you know, I have an allergy. I'm not going to say what I'm allergic to, because that might invite another kind of hacking, biohacking. But I have an allergy, and when I was younger, at university, abroad, I was made to wear a bracelet. And the bracelet contained information about the allergy. I say made to wear because it wasn't mandatory, but it was an option in the event that I have a reaction in which I can't communicate, and the officers responding will use their device and read the bracelet and have the information. Sir, the only specific information, the information that I've just given you is what sits on all cards, and only that. That information in different environments, like the polyclinic, the licensing authority, the University of the West Indies, if those services are onboarded, whatever services are onboarded, those original credentials are all that exist. They are then used for the institution in whose device you are entering your PIN to then use that to access administrative information that they have in their records. The card itself does not carry that information. It is only when you authorize the access that the Queen Elizabeth Hospital, for example, should we move to that functionality, will then say, oh, I am sure that this is George Brown. I have the proof of George Brown's address. I have his PIN. So I know that he is presenting authentically in this user case. On that basis, I am going to pull George Brown's information and proceed to whatever is the transaction in which he wishes to engage. Only the user in the institution that has access to that administrative data can access that information. All your card does in that environment is makes them sure, beyond a shadow of a doubt, that it is you. Sir, as I close, the member for Christchurch Essential will appreciate this. There is an individual with my exact name in the Ministry of Finance. My exact name. In the Ministry of Finance, ironically, a ministry in which I worked for many years. Barbados is so small. She and I have the same service provider in a range of areas. You know how I know that? Because I show up, and the person behind the desk, to their credit, asked me to verify my address because they have two of us. And I tell them, but here's the rub. I know the young lady's address, so I could have given them hers. When I use my card and I put it into their system and I put in my PIN, it could only be me, sir. And they're not depending on my say-so. That is the information that they see, that is secured. Sir, I am not surprised that there is an environment of, I won't say mistrust, but perhaps, given the global reality, that people want evidence of security. The digital ID, the steps we are taking with respect to cybersecurity, these are all for the purpose of protecting the consumer and making it easier to carry out business day by day. Ask the staff of the Electoral and Boundaries Commission how many forged old ID cards they have come into contact with. How many replicated, how a person with a laminator and a piece of blue paper can type on a card and scribble something on it and say, this is so-and-so's ID card. That technology, if I could call it that loosely, was more susceptible to forgery than this current technology. And I'm not saying that we do not have a responsibility to prove our cybersecurity capacity. Absolutely we do, and we will. But the whole point, sir, both of the legislation and of the ID card and associated functionality is to secure the consumer. I just want, before I take my seat, to respond to the notion that, and I will say to the producers of this document, the team and I will talk with you. We will talk to the country. We only have an interest in strengthening security, not in convincing people that we are secure when we are not, because that will soon come to light. The notion that there was, in December, a leak of the preliminary voters list, in December 2021. The individuals consider that in December 2021, a list of Barbadians with our names, national registration number, gender, date of birth, residential status, constituency, polling station, and address was exposed to the open web. That's the categorization. And that even though it was since removed, the document could be downloaded by anyone with access to the internet, has been shared multiple times, and so on. Sir, the Register of Electors is a matter of public record. This information is available to the public. Sir, the fact is that your national registration number, unlike identifiers in other jurisdictions, your national registration number does not in itself give you access to any goods or services or benefits that can be stolen once a person is in possession of the number, just knowing that number. So I can't show up and say, my ID number is so-and-so, and so I want the pension check for the member for Christ Church East Central, right? There are other credentials that have to exist at the same time that you have to present with. Now, I understand, and the data commissioner will be the first to tell you that there is a different level of accessibility when something is in an online environment as opposed to when I have to go physically to a place and look for it. The fact of its publication is the same. So the voters list is published. Preliminary lists are published as the Register of Electors is updated, and then closer to when a general election is called, a final list is published is a matter of public record. Anybody can have it and keep it year after year after year. Now, where I understand people's surprise, perhaps, was that that may have been the first time that it was published online. There's a conversation to be had about differences in accessibility, but certainly whether it is online or physical, the fact of it being available online does not give a holder of the document any more power to engage in unlawful activity using your information than they previously had for all the decades that the list was being published. We must, as a country, come to a common understanding of what information should be in the public domain. Sir, we have CCTV cameras all over, here in other jurisdictions. In another place in which I lived, the fact of CC cameras alone, their presence, meant that you could essentially trace my movements for a 24-hour period. Where I lived at that time, the residents had advocated aggressively for more cameras because they had had instances where the authorities were not able to investigate and prosecute crimes because they did not have the evidence that would have allowed them to do so. There were no cameras in place and so on. We have, as a country, to agree on what are the acceptable risks, and I say acceptable because what is the real risk to you of an address being known publicly that is right now in the directory? The group considers that the publication of the list online made them susceptible to stalking, breaking and entering. How so as against a telephone directory? How so as against going to the Electoral and Boundaries Commission and getting a copy of the list? So, sir, as I said, my desire is not to trivialize or dismiss any concern of any individual. I think that it is our collective responsibility to, one, demonstrate security and confidence from the government and from the private sector, because the government doesn't run commercial banks in this country, which probably represent the greatest capacity for financial risk and loss. And I noticed that the credit unions, the banks, are, as we speak, beefing up their cybersecurity capacity, as must government. But we need to collectively determine if we want the benefits that we say we want, what does that mean for the information that we share about ourselves? Given that we have an expectation that those who administer the information are doing so with the utmost security and safety in mind. And also that each individual has a responsibility to act in a way that keeps them safe. That cannot be understated. And so, if you see a link from a person that looks, sometimes I get a message, the link looks strange. And I will call the person or message the person and say, did you send me this and what is this? Because I'm not clicking on it. There are friends of mine who know warn me first, because I am not clicking on anything that you send me. New AI technology. And we must move to the place where we adopt and understand technology. But new AI technology will mean that the member for St. James South, I see her calling me and I answer. And I say hello and it is her voice. And she says to me, come quick. My car stalled in some water here at Boston University Hill, come quick. Except that is not the member for St. James South. It is an AI-generated voice made to call from her number so that I can act in a way that might put myself at risk, that may mean financial gain for the individual calling. These are all things that we have to deal with. And a lot of the guidance now is saying, if that happens to you, especially if it is a call for a ransom, somebody says they've been kidnapped, somebody says they're in some kind of suspicious circumstance, hang up, call them back, perhaps on a different number. Regrettably, these are things that are affecting us today. And we do not want to be paranoid, but we have to be careful. So, sir, I have to emphasize that issues related to cybersecurity threats, defense strategies, and methods are also matters of national security. So while we agree to come and have this conversation, these issues will continue to be the subject of discussions with the National Security Council. We as a government will go as far as possible in sharing with citizens enough information to create confidence and improve education so Barbadians also protect themselves, but we cannot disclose everything. We will not announce to the world any specific vulnerabilities that we are addressing or any gaps in our coverage that we are working to close, because that in itself is a cybersecurity risk. You don't win a battle by drawing a target on your chest and showing your enemy where to hit you. And in all matters of national security, that has been and must continue to be our approach. So we will go as far as we can in discussing the strategy, but we cannot declare all. Sir, I want to give my thanks of the Cabinet to the Law Reform Commission that continues to do tremendous work and has done human service in bringing this bill to where the point of consideration before us today. Again, I must thank the ministers, the members for St. Michael West and St. Philip West and St. Michael North. This bill benefited from both their stewardship, and it has been a lot of work. And so, again, I thank them for their contribution to this, another important transformation. All the stakeholders who participated in these consultations, both within and outside government, the officials from the Council of Europe, who continued to give support to the Minister, to the Attorney General, to the Law Reform Commission. Mr. Speaker, I have to especially thank the Attorney General, who, by virtue not just of his office, but of his inclination, was a senior minister to many of us, and generosity of spirit, of course, and modesty. But with those inclinations, sir, has been a senior minister to many of us long before that title was created. And I have to say, sir, that he embodies the practice of being at once a peer and an advisor, of guiding in partnership rather than hierarchy, and I consider it a worthwhile lesson in approach. Sir, with those thanks, I commend this bill to this honorable place, and I beg that it be read a second time.
Beg to second that, sir.
Honourable Member for St. Joseph.
Mr. Speaker, I'm proposing that we take our lunch break now and therefore suspend the chamber until 2:30. But if you would permit me just to say that I'm very happy that we had students present at Parliament when they could see us at our most decorous selves and benefit from among the finest speeches and from this finest speaker that this chamber has to offer. I beg to move that we adjourn until 2:30.
The question is that this honourable chamber be suspended until 2:30 p.m. All of our members in favor, please say aye. Those against, please say no. Me think the ayes have it. This honourable chamber stands suspended until 2:30 p.m.